Today, I am very happy to have the opportunity to host Sarah Cotter, Senior Employment Lawyer with Minkin Employment Lawyers. Alpha One Canada was excited to have Sarah agree to join us today to address the Canadian Alpha One patient community's most frequently asked questions related to their ongoing concerns about returning to the workplace and or to school during the pandemic. Sarah is an employment law expert with Minkin Employment Lawyers, where she started her career in 2004. Sarah is known for helping both employees and employers with the challenges they face, including matters relating to wrongful dismissal, constructive dismissal, human rights issues, workplace violence and harassment, as well as the drafting of employment contracts and policies. And I'd like to thank you for joining us here today, Sarah.
Thank you so much. It's an honor to be here and to be able to provide this information to your members. I know that this is a very stressful time for everyone, and for people who have compromised immune systems, it's going to be an even more stressful time. So I'm happy to be able to share some information.
Wonderful. And I as we have discussed, this is for information purposes only.
Yes. This is general information that I'm providing. It's not legal advice, and there is no solicitor-client relationship that is established through watching this video. If anyone is interested in obtaining more information and entering into a relationship, solicitor-client relationship, I'm more than happy to do that. But this is just general information.
Great, and we will be including your information at the end of the video. If anyone wants to reach out to you, then they'll have your direct contact information. So thank you for stating that. Mm-hmm. The first question we received actually was from a patient that wrote us saying, I do not want to disclose to my employer that I have a chronic disease, but due to my Alpha 1, I do not want to return to work. Can I refuse to return to work without disclosing my medical condition?
So I appreciate that, medical conditions are sensitive, and not everyone wants to disclose that information. But from an employment law standpoint, if you refuse to return to work, that can be viewed as a resignation or an abandonment of your position. So that's something that I would caution, and employees never want to be in that situation. So it is recommended that some information be shared if there are concerns about returning to work, to trigger the employer's duty to accommodate. And that duty to accommodate falls under human rights legislation, but there has to be an understanding or some information that's communicated to the employer that there is a medical need and that there is a need for accommodation to then roll out that process. So a complete medical history is obviously not required, but some information needs to be shared to trigger that duty to accommodate. And sometimes there may be a concern about returning to work, but it might be possible to work remotely or come up with some other arrangement that can allow the employee to continue to work, but address their specific concerns, which is obviously the risk to their health. So it would be a good idea to engage in some sort of dialogue with the employer first. And again, disclosing the fact that there is a higher risk due to an underlying medical condition, but you don't need to disclose anything more at that point. Some information beyond that might be required if there is going to be a discussion about accommodation, to ascertain sort of what is reasonable in the circumstances. But certainly, just refusing to return to work is something that can be problematic and may result in the ending of the employment relationship.
Interesting. Okay. And in keeping with that, another patient had asked, does the company have the right to ask about my health history? And do they have the right to take my temperature, I'm assuming upon entering the workplace?
Mm-hmm. So employers do have an obligation to ensure a safe workplace and a safe working environment. And so to that extent, some questions can be asked. And certainly now in this COVID environment, a lot of things have changed. And there's always been competing, interests between employers and employees, the right to privacy, the employer's duty to provide a safe working environment. So employers do have the ability to ask some questions about an employee's health to make sure that a safe environment is being created, but certainly not an employee's entire health history needs to be disclosed. So a lot of companies now in this COVID environment are creating policies and procedures that are being communicated to employees in advance that indicate that upon entry, questions will be asked about health conditions, and temperature checks are becoming more and more common. So if that policy is in place and the employee knows in advance, and if it's being done discreetly and as privately as possible, and if all employees are being treated the same and subject to the same checks, then likely that's something that employers are able to do. And particularly now, they're very non-invasive. If it was a more invasive test, then that would be something that I think would be a different conversation. But in answer to that question, if there's a policy and procedure in place and the employee knows in advance, then temperature checks, non-invasive temperature checks are likely okay. And but an employee certainly does not have to disclose their entire medical history. No.
Okay. Good to know. Unfortunately, the next question we received several of them that were quite similar. And this patient had asked had mentioned that due to current financial constraints related to the pandemic, their employer has changed their healthcare benefits, and those benefits provided coverage for their augmentation therapy. The employee's new package no longer provides the coverage. How much advanced warning is an employer required to give when they opt to change healthcare coverage?
Right. Okay. So there's no sort of, hard and fast rules in terms of how much time needs to be required. It is very much fact specific and depending on the circumstances. Employers do have a certain amount of leeway to make some changes to the terms of an employee's employment, and changing benefit plans is something that can be done, but enough notice has to be provided. Otherwise it can be viewed as a constructive dismissal situation. So in terms of how much notice can be provided will be dependent on a couple things. So a lot of employers have contracts in place with the employee. So hiring letters, employment agreements that clearly set out that changes may be made, and if changes are going to be made, how much notice will be provided in those circumstances. Policies, also handbooks, sometimes those things set out those policies and procedures. So that's the first place to look to see if there's something that has previously been agreed to that sets out the time frame, and employers should be adhering to that. If there is no policy or procedure in place, then it would revert back to sort of the common law principles that exist, and that's usually why people come to speak to an employment law lawyer. So an employer may be obligated to provide the same amount of notice that the employee would be entitled to if they were being terminated, and that can be a long period of time. So it's dependent on a number of factors. So how long has the employee been there? What's their level, their position, their level of responsibility, their age? Those are the things that typically go into common law notice. Sometimes employers will provide notice that is equivalent to the employee's statutory minimums under the, in Ontario, it's the Employment Standards Act. So that would be a shorter period of time than the common law periods. So it really is very fact specific, but notice should be provided. It's not a change that employers can just make right away on the spot and not provide any notice.
Right, okay, thank you. Another question about employee screening. A patient had contacted us noting, as an alpha patient, I have a chronic cough and shortness of breath. Am I required to disclose this on the daily screening checks my employer has put in place? So again, I think a lot of that will depend on what the specific policies and procedures are that the employer has established, because that will set out is it, chronic symptoms that need to be disclosed, or is it just new and unexplained symptoms? And what I'm finding is a lot of the questions that are being asked, and not just with employers. I mean, I'm finding this when I'm going for, when I went to the dentist, when I took my daughter to the eye doctor, a lot of people who are providing services are asking about new and unexplained circumstances. So if there's a patient who has a chronic condition and nothing sort of unexplained or out of the ordinary is happening, then, depending on what the specific question is, likely they don't have to disclose it because that's their sort of standard state of being. Okay. It would just be if something new and unexplained that could potentially be a COVID symptom is being experienced, that's when it likely would need to be disclosed. And I think if an employee has previously informed their employer that they do have these chronic conditions, they likely don't need to keep saying that every day. Right. That makes
Mhm.
sense.
Yeah.
An interesting question came up about WSIB, and the question was, does WSIB provide coverage if someone was to contract COVID-19 while at work?
Mhm. So yes, the answer is yes, that in certain circumstances on a case-by-case basis, employees can be entitled to WSIB benefits if they contract COVID while at work. So a couple things need to be proved. So obviously there needs to be a proven case of COVID. If there's a situation where there's a suspected case, but it's not actually proven and there's no symptoms, then that wouldn't be covered. But if there's a proven case, and if the employee can establish that their working environment puts them at a greater risk for COVID based on those specific circumstances, those are sort of the two main things that that WSIB will look at. And then there's other factors that they go into if necessary. But those are the two main things that they look at, or that are required to proceed further with the analysis.
Okay, great. We have received, again, several inquiries around whether or not employers are required to supply PPE to all staff. We heard from a patient who was concerned because their office has no plexiglass shields or other barriers to block airborne particles. So is the employer required to provide this type of protection?
Mm-hmm. So generally, yes, employers do have an obligation to provide a healthy and safe working environment and to ensure the safety of their employees. And that includes protection against illnesses, which COVID would fall into that category. So yes, employers are obligated to provide PPE for their employees. In terms of barriers and what should be provided, that is going to be context specific, and it will really depend on the nature of the workplace, who's coming in and out of that workplace. Is it just sort of the employees themselves, or is members of the public coming in and out? If it's possible and reasonable in the circumstances to create sort of plexiglass barriers, then that is something that likely an employer should be doing. It's not going to be possible to sort of have everyone in their own little plexiglass boxes, but certainly where there's high risk areas, it's something that employers should be doing. And if there is a concern that that's not being done, then the employee should address that with their employer.
Okay, makes sense. Another question about returning to work. A patient had asked us, if they do not want to return to work, can their employer force them to take unused vacation time?
So an employer likely can't force an employee to take unused vacation time, but if the alternative would be an unpaid leave of absence, then the employee may want to take that vacation time. But it can't be forced. I know that the federal government for federal employees on one of their websites was encouraging employees to take vacation time that has been accrued in the year that it has been accrued. So, it might be a good idea, even though, for whatever reason that employee doesn't necessarily want to do that, but they can't be forced.
So a question that came in from a caregiver, a spouse, wrote us asking, my husband is an alpha-1 patient and is immunocompromised. Can I stay home instead of returning to work? I fear bringing the virus home to him. This isn't a patient, but the spouse of a patient.
Family member, yeah. So that's a bit of a gray area. There are sort of different aspects of the law that touch upon that and can potentially provide a solution. So I think the first thing to do would certainly be to reach out to the employer and express the concern and see if it's possible to come up with some sort of arrangement. So again, it could be a working from home arrangement. It could be something where the employee is working, but maybe at times that are less busy, less employees around. So something may be able to be arranged with the employer that allows the employee to continue working, but still make sure that the spouse is being protected. There are, as I said, there are different aspects of the law. So, potentially there can be a request for accommodation based on marital status, which is a protected ground under the Human Rights Code. In Ontario, there's the new infectious disease emergency leave, which can apply in certain situations. So if an employee is caring for someone who has COVID or caring for someone who's compromised, then there can be situations where that leave can be taken. So I think the first thing to do is definitely have a discussion with the employer and, you know, speak to a lawyer to see if there are other types of job protected leaves or accommodation that might be available in those circumstances.
Okay. An interesting question came from a patient out east. Does my employer have to tell me if a coworker is diagnosed with COVID-19?
Yeah, so that again, that's another bit of a gray area, and it is really sort of illustrating the conflicting priorities between maintaining privacy, but at the same time making sure employees are safe and that employers are doing their due diligence to create a safe working environment. So what I think would need to be done in a circumstance like that is that the employees who would be most at risk because of being in contact with the employee who came down with the illness would likely need to be informed that someone has come down with the illness. So probably it would be better, if possible, not to name the worker who got sick, but to sort of say, listen, you know, a worker in this department, in this area, you know, someone you were sharing space with on these days has now been ill, so we want to alert you so you can take steps to self-quarantine and that sort of process. So I think that would be the immediate thing. And I think likely later on, more of a sort of general email would go out to other employees who weren't necessarily in contact with that employee, but just giving them the heads up that someone has been ill and that steps have been taken to make sure that it has not, that it's been contained, without giving more information than is necessary with respect to that, you know, worker's identity, to make sure that their privacy is protected as much as possible. So it's always that balancing act.
Right. Well, that brings us to our last frequently asked question. This patient had sent in a question that stated, my employer is not following public health guidelines to keep employees or customers safe. Is this patient, this alpha patient, required or legally required to report this?
So I would say that there's no legal requirement to report it. However, if there is a concern, it's certainly something that should be addressed with the employer. And I think it's always better to speak to the employer first, to raise the concerns, give the employer an ability to address the situation, because it could be that the employer just really isn't aware. And once it's brought to their attention, they will do what's necessary to fix it. If it's a situation where the employer knows what they ought to be doing and just doesn't really feel like doing it, then after the employee addresses that with the employer and is not getting sort of a satisfactory response, then it can be reported. In Ontario, it would be reported to the Ministry of Labour, and then typically what happens is an investigator would be assigned to go in and investigate the situation and make a finding in terms of whether or not it is safe or not. So, you know, but the employee can speak to either the owner, their supervisor, or someone in human resources, or if there's a health and safety committee, then it can be brought to that person's attention too.
Okay. Now, all excellent points. It seems that the common theme would be really just to keep that communication open between employee and employer. Would that be a fair assessment?
Yes. Yeah, I think that is very critical, because I think a lot of times in the employment relationship, people may not realize it, but emotions can run high in the workplace. And I think that there's sometimes this thought that, oh, you know, someone's not doing something that's properly done, and because they don't want to, or because they don't care about the workers, or what have you. And sometimes employers they're not all that sophisticated. They don't always know what their obligations are. And sometimes a quick conversation can address it. And it's better than sort of having something fester and potentially blow up into something that it doesn't need to be. So my approach is always have a conversation, see where that goes. And if it's not going the way, you know, the patient is hoping it's going to go, that's when it makes sense to escalate and seek the advice of a lawyer to see what can be done, and then what potential legal remedies are available in that circumstance.
Okay, that makes sense. Well, I can't thank you enough, Sarah, for answering our top 10 frequently asked employment questions. On behalf of the Canadian Alpha community, thank you very much for your time. We will be posting your information, your email contact, and telephone information at the end of this video for anyone who wants to reach out to you directly and ask a very specific question. They can contact you. So thank you so much for your time. We really appreciate it.